I'm Jette Ferguson with Sotheby's International Realty here in Carmel with guest KRASA, trust attorney.
Hello. Yes.
And talk about winging it. Today, we literally just arrived, plopped down in these seats, and Kyle has no idea what I'm going to ask. That's because I have no idea what I'm going to ask, but let's do it anyway. So, Kyle happens to be my trust attorney, my family's trust attorney, and why don't you just tell people what a trust is in
Sure.
general to get started?
Well, Jet, we all take for granted the fact that we have the basic civil right to make financial decisions for ourselves, that we can decide how we're going to earn our money, how we're going to spend our money, how we're going to invest our money, whether and to what extent we're going to make gifts. And the question is, what happens when we no longer have the ability to make those decisions directly because of incapacity or because of death? And so the idea behind putting together an estate plan with a trust is so we can maintain that control, so we can make sure that if we lose capacity because of a stroke or something, people that we trust can manage our assets for us.
Makes sense.
And then without having any involvement with the courts, that it can be private and done efficiently.
So avoid probate.
Avoid conservatorship during incapacity and avoid probate at death. And so the same idea, if we pass away, we want to make sure that people that we choose would have the ability to manage our assets, sell our property, or transfer our property to our loved ones, to children or other people, without having to go through probate and without having to have unnecessary expense or delay.
Okay. So I had a trust attorney before you, sorry, but then I found you.
Right.
So we had an issue that we didn't know we had until we went to you to update our trust, and that was you told us they weren't connected basically
the assets weren't in the trust, and that is a very
not good.
common problem with trust planning. Most people agree that trusts are the most efficient way to avoid probate and conservatorship, and they think drafting the trust is the end of the story. But really, the other part of it is you have to make sure that title to all your assets is transferred into the trust.
Okay.
The analogy that I usually use is think of your trust as an empty basket, and all your assets, your home, maybe other real properties, bank accounts, they're all like little eggs, and we need to get the eggs in the basket. And so that process of transferring the eggs into the basket, of retitling all the assets to you as trustee of your trust, is known as trust funding. And a lot of attorneys will not do the trust funding for you. Maybe they'll do some of the real property, the deeds, but they won't do the bank accounts. They won't do your beneficiary designations on your retirement plans and your life insurance. And that's such a critical part, because if the assets are not titled to the trust, then all the things that we wanted to use the trust for, to avoid conservatorship and to avoid probate, are probably not going to work.
You probably paid for that, and it doesn't really work the way you wanted.
You did your trust, you signed it, you thought you were done. I took care of it. I'm not going to have a probate, and you pass away, and we discover 3 or 4 assets are left outside of the trust, and depending upon the value and depending upon a number of other circumstances, you might have a probate anyway.
That's not good.
You don't want to. You never want to probate, but you definitely don't want to probate if you took the time and invested your money into putting together a trust and still have a probate anyway.
Okay, that makes sense. So I hired the attorney before, had everything written up exactly where we wanted it to go, but I didn't understand that the attorney didn't do that, and I didn't do that. So then we were left with it. The eggs were not in the basket.
The eggs were not in the basket, and the reason why we discovered that is because I asked you and your husband to fill out an asset questionnaire for me and to list all the assets that you had. And then what we did is, for real property, we looked at the deed. We pulled the deed, and we could see that the real property was not in the trust. With the bank accounts and other investment accounts and so forth, we wrote letters to the institutions, and we asked them to please make sure that the assets are in the trust, and if not, to do whatever steps they need to take in order to put them in the trust. So we did discover some loose eggs.
But you did that for us.
We did that for you. And the reason why I think it's important, most attorneys don't do it because it is a lot of work.
Right.
And perhaps there's more liability and responsibility for that. But I feel strongly that if clients should come to an attorney feeling that it's going to be taken care of.
Right.
And
they kind of think that even if
of course they do. Yeah.
Don't know, so.
They do. And, I can't sign the signature cards for you, but I can alert the bank that we have this issue, that we want the assets in the trust.
Yeah.
And I can I can help you marshal the steps.
Oh,
I can
yeah,
make
you
sure.
tracked us down
Right.
and you made us do
That's
it,
right.
which
And
I
kept,
appreciate.
And I kept telling you, make sure it's in there. Did you go to the bank yet? And you finally did.
I finally did, months later.
But you did. But it's because of that interaction
Right.
that I didn't let you forget about it.
Exactly.
And I also alerted the bank to the issue so they were aware of it. And they probably contacted you as well and
Yes.
said, hey, we're aware that you did a trust and that you want your assets in the trust.
Right.
And so you eventually went through. So I find even though I can't sign the signature cards for you,
Right.
I find if I write the letters to the banks and if I follow up and I make you aware of the situation
Right.
and I follow up with you and the banks are aware, it's much more likely that you're going to get your assets in the trust and
Right.
you're going to get them correctly. And when clients are left to do it on their own, sometimes they're successful at doing one or two of their assets, but
Right.
sometimes they run into roadblocks. The institutions might need more information and they get discouraged and they don't know. And of course, if we're asked, can we provide this document or that document, we know what they're asking.
Exactly.
And we can provide it to them. And
Makes
so we
sense.
can just help guide you through that process. And I think
Right.
it's very important.
I agree. I'm so thankful that you told us that because we
Yeah.
would be today without our eggs in the basket.
And probably not knowing that, not
and not
realizing
knowing
it.
that.
Right.
So a lot of people don't know that. So if you're watching this, at least call your trust attorney and ask, or call your banks and ask, and make sure it's titled that your house is actually attached to it. Funded.
Funded. That's right.
Wrong word. Okay. So since I'm just throwing out questions off the top, I kind of
Sure.
want to see is there anything that's an obvious mistake that people make all the time?
Well, the trust funding is
That's
probably the
obviously-
biggest issue.
Yeah.
I think not understanding that the trust does need to be updated from time to time.
Okay.
If there are changes in your family circumstances, certainly if there's a death or a birth, a divorce, a marriage,
Right.
that might necessitate a second look at the trust. Trust laws change, strategies change,
Mm-hmm.
so it's a good idea to have your estate plan reviewed with a qualified attorney every few years. I'd say every 4 to 5 years.
Oh, I think it's
You
time
might
for
be-
us again.
We might be ready for that at some
Yeah.
time. And there are all kinds of new strategies all the time.
Okay.
So we often will talk about trusts to avoid probate and conservatorship, which are really important, but
Sure.
that's not all a trust can do.
Right.
And we talked about this before with the trust, especially with your
And
with
medical.
your family. Right. There's the medical aspect as well. And then also, trust can be set in place where the inheritance can be protected. So if your beneficiaries
Mm-hmm.
have some creditor issue or some divorce issue, there can be built-in protection to that inheritance. And that's something that more and more attorneys are starting to focus on, that we never used to really look at that so much.
So I want it to go to this person, whether they're married or not? Or
That's right. And
Okay.
to make sure that if they later get divorced,
Right.
that it's not going to be part of the divorce.
Right.
Or you give it to your beneficiary, and if later the beneficiary gets into trouble, gets into a car accident, is sued, we can at least provide some protection for the inheritance. And so
Right.
there are all kinds of ways that we can use trust to provide a whole host of protections that traditionally older trusts probably just don't address.
Right. Now, in speaking to the medical,
Mm-hmm.
I'm thinking everyone might not understand, but correct me if I'm wrong. This is the person you want to trust to pull the plug or not, right?
That's right. So with any estate plan, your trust is your main document as far as dealing with your assets.
Sure.
Management and distribution of your assets in the event of incapacity or death. But there's more to it with estate planning. We want to think about health decisions.
Right.
So any estate plan, in addition to a trust, should also have some healthcare documents.
Sure.
One would be an advanced healthcare directive.
Right.
Sometimes that's referred to as a healthcare power of attorney.
Yes.
Sometimes it's referred to as a living will.
Okay.
The idea behind that is that you name someone who has the ability to make healthcare decisions for you,
Right.
talk to the doctors, direct them what to do in the event that you're not able to do that.
And sometimes a married couple has very differing views on that. I found
That's
that out
right.
with my own husband because
Right.
we do have different views. I'm like, okay, get rid of me quick.
And that is important when you're choosing your healthcare agents. First of all, you want to name backups in case the first one is unable to
Sure.
act for whatever reason or they just can't be located. But when you're picking the agent, you do want to have an idea of, do they have the same views as you do?
Sure.
If they don't, will they be comfortable? Can you communicate what your views are?
Right. Will they follow what you want?
That's right. Will they be comfortable doing something different for you that they would want for themselves?
Right.
And with a healthcare directive, you're able to at least put in writing some of those terms. You can be very detailed, you can be very general, but it's important to have that comfort level and have that difficult conversation. It's not easy to talk about that.
It's difficult, but it's also kind of a cool conversation. I felt like I really got to know my husband more by having this conversation at this level, that if I'm in this medical situation, I want this, if I'm in this situation, and then I was surprised that he had different answers than I did.
That's right.
So it was kind of really getting to know your partner better in a way.
Right.
So anything else that you have off the top of the head? Because I want to have you back if you're willing to.
I'd be happy to come back and talk in more detail about different strategies.
And hopefully we'll have an audience bigger than my mom, Karen Calandra. Hi, Mom.
Hi, Karen. We like your mom. I'm happy to do this just for your mom, if your mom's the only one watching. Well, great. Well, thank you so much for having me.
Thank you so much for coming. I really appreciate you taking the time.
Absolutely. Thank you.
Thanks, Kyle.
All right.